Okay, so I'm just going to do a very quick topic on troubleshooting virtual arbitrations. And really, as Ms. Maria showed, the interface in virtual arbitrations today is so vastly different from how we used to do, for example, physical hearings where everybody comes into a room, everybody flies in to one location, particularly if you have, parties from different locations, counsels from different locations, witnesses and experts from different locations. It's a different kind of logistical arrangement. It's a different kind of coordination. It's a different kind of planning for a physical hearing than if you have a remote hearing. And really, one of the things that I see that when you move into this a different paradigm of virtual arbitrations is that in every stage of the proceedings, and you have here before the screen some of the usual stages that may happen in arbitration, there is really an opportunity to be able to adapt, to be able to make sure or to prime your arbitration for success. So for me personally, what we do is that as early as possible, you want to be able to agree with the other parties what you're going to do whenever certain situations arise. So one of the best ways to do this is to, for example, agree on certain protocols. So for example, you have appointed the tribunal, which is on the second part of your screen there. Usually the tribunal would, call for a case management conference just to set the entire procedural timetable for the rest of the hearing, for example. If you already know that you're going to be conducting virtual hearings, this may be a good time to try to understand what do the parties want, what are the parties' objectives in making sure that all of the flexibility is really taken advantage of. Before you proceed to an evidentiary hearing, for example, which is near the end of the proceeding, you can also have a pre-hearing conference. And again, these are the times when you can adopt different kinds of protocols, maybe cybersecurity protocols or e-hearing virtual protocols, just to make sure that everybody's on the same page and you're not running into situations which are completely unwelcome. And these I will turn to in the next slide. So what are these kinds of examples? Like I said, these are situations which you don't actually encounter in regular physical hearings. So one scenario would be when you look at, you already have, you've agreed to a virtual hearing because, everybody's locked down, you can't really travel, it's not advisable to travel, and you probably shouldn't. And then you look at your applicable law or the procedural rules, and it says, or you look, at your arbitration agreement, and it actually says, oh, there is a requirement that the hearing must be conducted in person. And the issue here becomes, a potential problem of enforcement. It may be that if you go ahead and proceed anyway with the virtual hearing, you may run into an issue of enforcement because the other party, usually the losing party, will say, well, the arbitration was not conducted in accordance with the party's agreement. Of course, there are potential solutions to this. One would be you could obtain a party's consent to virtual hearings. You could check the law governing the arbitration, or particularly the laws governing the jurisdictions of enforcement. Maybe you consult local counsel and say, hey, if I enforce my award here, it was, and this is a scenario, is the court, or what is the court's approach to this kind of situation? And you check the applicable rules. So while it's great to have a virtual hearing because you do save a certain amount of costs and time, it may or may not be worth the risk of maybe potentially risking your enforcement. So that's really, it's really a question, it's a case-to-case basis, but that's one particular scenario that doesn't actually appear often in physical hearings, but which may appear in virtual hearing. A second scenario, a little bit more practical, is you have your ongoing virtual hearing and everything's all set up. You've already put into place, everybody's in place, doing making their cross-examination, and then suddenly the video or the audio feed cuts out completely for one side during the hearing. So, and while we think it's just a regular technical issue, yes, that's true, but at the same time, it could have certain due process implications. One of the parties may say, hey, you know what, I wasn't actually given the chance to present my case properly. It was unfair for me. I was deprived of this opportunity. That's one issue. Another issue is that cost. Because of maybe a technical interruption, you have to reschedule, you have to postpone a hearing. All of these would entail costs. Every hour, to be honest, that you spend a bit longer will entail additional costs for your counsels, for your arbitrators, for the service providers. So who bears those costs? Who bears the burden of when a technical glitch happens? And like I said at the beginning, it's really very useful to have a protocol or an agreement already to decide these kinds of things, so that if they do come up, you already know how to handle them. At the same time, a possible solution is, if something happens like this, it's really best that, if the tribunal doesn't do it on their own, one of the counsels will approach the tribunal and say, ask them to, quote unquote, cure the technical defect, maybe, adjourn the proceedings if you really cannot proceed with one of the parties being present. So these are the things to bear in mind. Another scenario, which is kind of similar, is if your video or audio feed gets hacked or it's hijacked. I think, in the early days of the pandemic, and then everybody was doing Zoom calls, we've had all these reports about Zoom bombing and people just suddenly showing up, and they're very inconvenient. But at the same time, when you have very high stakes arbitrations, the more serious consideration is that it could lead to a leak of confidential or sensitive information being leaked. It could lead to, parties being compromised. So you'd want to avoid these as much as possible. As I mentioned, you could have a protocol at the beginning, a cybersecurity protocol. Make sure you have sufficient encryption for all your information. Use a reputable service. Use institutions, because there are now a number of institutions which actually offer virtual hearing services, and most of them are reputable. And you can have them as a third-party neutral, be the one to control the proceedings and gatekeep the process. So you provide them with a list of certain people, and these are the only ones who are allowed to join the hearing. They're able to gatekeep the process, make sure everything runs smoothly. Another scenario is, for example, one of your tribunals, counsels, or witness experiences technical difficulties. So, this is similar to my earlier example, and this leads to an interruption or a break in the testimony or questions or instructions, basically interrupts the smooth flow of your hearing. And at the end of the day, it really just affects a party's ability to present their case. And again, there are cost implications, and it's at the minimum, is really disruptive to the proceedings. If you're if you're conducting your cross-examination and you're building up to a really good point, and then suddenly you have technical difficulties, it's really incredibly disruptive. It could break the flow of your questioning. It could break the way you were trying to arrive at a point, which could be very, very critical to your case. So as much as possible, it's great to invest in proper equipment, high-speed internet, a webcam, microphone. The problem really here, sometimes you have witnesses or parties in remote locations, maybe sometimes not of their own choosing, they didn't want to be there, but they were constrained by circumstances. And if the witness is crucial, if it's a critical witness, you have to consider, is it best to just postpone the hearing? If one of the parties usually is in a place where internet is not always, connectivity is not always great, that's something to consider. Is it something that you want to risk just because you want to arrive at a resolution of your dispute maybe a few months earlier? So of course, there are no cut and dry solutions. You really have to take into account many different factors. Oh, and yes, so I put in here e-bundles. And I think that's one of a really great thing about having more virtual hearings, is that the use of e-bundles is a lot more prevalent now, at least I found, and even for smaller arbitrations where sometimes the cost of procuring an e-bundle service is not always does not always justify the amount in dispute. But because a lot of the hearings have become virtual, And it's really encouraged the use of e-bundles, making sure everything is cross-referenced and everything is a lot easier to access for both the parties, the counsel, and the tribunal. So as much as possible, if you could have access to these kinds of services, it's really great to have them, and it could lead to, it'll avoid interruptions. It'll avoid, waste of time in looking for a particular document, especially if you have stacks and stacks of documents that you need to go through. Another scenario, which I think is quite interesting, is when a witness cheats, in quotation marks, by having someone in the room or having notes. So usually, it doesn't always happen. And most of the time, a lot of counsels, a lot of parties actually really want to protect their reputation, and they won't do this. But it is possible that you have a witness in a remote setting. Counsels cannot always control their witnesses. And usually sometimes you don't know, they may look like they're alone in the room, but you can't see the other side of the room. They look like they may be talking to someone, and aren't they? And you don't want to cast aspersions unjustifiably. So a good way to avoid this, or to ring fence this issue, is when you can ask the tribunal, or the tribunal will usually do it on its own, that they'll confirm that the witness is alone, they don't have any notes with them. When you feel that there's a high risk of your witness being compromised, or the integrity of the testimony being compromised, some parties agree to have rotating cameras, or at least the camera pans towards the room at least once before the witness starts presenting. Or you can have, it's very practical solutions is really just to have maybe two cameras, one at the front, one at the back. There are many different ways, but the important thing really is to consider all these issues which may arise before they do, so that when they do arise, you already have a set mode of solutions that you can implement straight away. And lastly, I'll just go into, and I think Maria touched on this earlier, most of the time when you have, quite large arbitrations, it's really possible that your tribunal, your counsel, your witnesses, your experts are, across different jurisdictions, and it's really hard to schedule. And it's not only that, sometimes, if one of your witnesses, if you have witnesses who will unfortunately have to go on the stand at a time which is maybe 3 a.m. their time, it's really, there's always a human factor in arbitrations, and you can't escape the fact that it can be very difficult for them. It can be very taxing for them. Most witnesses have day jobs, and they could be very tired from a long day, and then you have a 3 a.m. witness examination. So as much as possible, you try to, if you're the counsel presenting that witness, you try to get a favorable timing. You try to shorten the hearings or multiple tranches, just so you make sure that your witnesses are protected, your case is presented well, you're not put at a disadvantage. So, of course, another thing is that as compared to regular physical hearings where you usually have everybody in the same room, you can keep tabs on everybody. There's also a possibility that your witness might not just show up because you don't have sight of them. You can't really control them, and it's possible they also have their own lives going on wherever they are, and it's really hard to keep them all in the same room. They may be online waiting for their turn to present. They may be in the breakout room, but they may be called away from their screens for whatever reason. It's quite difficult to administer all the time. So a good way of doing this is, again, proper scheduling, very, very meticulous planning, just to make sure that none of the witnesses or your parties even are left in the dark, or they're everybody's well accounted for all the time. So this basically wraps up the situations some of the situations that could arise in a virtual hearing, which don't normally arise in physical hearings. And as much as there's you want to be able to use the advantages that virtual hearings can have in order to resolve disputes quickly, you should also consider the pros and cons of virtual arbitration. there are many things that you don't normally encounter in physical hearings that you wouldn't even think of, but could actually arise in a virtual hearing. And then and then you just have to be prepared for them. Like I said, one of the best things is really agree on certain protocols even before you begin. Try to anticipate any potential issues, and otherwise I do see that there's a lot of potential for virtual hearings and virtual arbitrations in the future, particularly because time and cost savings, and I think, as Maria touched on earlier, the potential to encourage diversity in arbitration, which I'm always very supportive of. So that's all for my presentation for now. Thank you.